In the last NoPixel video, NoPixel owner Koil defeated Tove and DW as they were suing for half the profits from NoPixel. In that video, I interviewed Koil's lead attorney, Larry Zerner. In the interview, I asked him, was Koil planning on suing for legal fees?
I got an email that said, well, first he wanted a dismissal. No, we're not agreeing to just dismissal. We want a judgment. We want the judge to rule that that we win, and then now we'll ask the judge for all our attorney fees and costs. And hopefully we'll get those too.
Now that day has come, and indeed Koil is suing Tove for a little under $250,000. And all of it's DW's fault, but Tove will have to foot the bill. But I have a sneaky suspicion DW will foot the bill. But DW and his legal team are not going down easy, as they have replied as to why they should not be liable for any of Koil's legal fees, as well as Larry Zerner replying to their reply as why they should be on the hook for all of Koil's legal fees. DW likely is hiding under a rock as he awaits for his visa to expire before leaving the United States on his own, or getting deported because this visa gets, reviewed and it looks a little suspicious.
What would you say you do here?
On November 7th, 2024, Larry Zerner filed to recover approximately $232,000 plus any fees that will be incurred, and preparing to reply to the opposition. Typically, the opposing party will try to argue that the total is too high in hopes of the judge bringing down the lawyer fees, but with Tove's track record, it might be best for them not to oppose, but since they couldn't help themselves, they did oppose, asking for less. So why is Koil's lawyer suing for legal fees? The easy answer is he won the lawsuit, but the techno answer can be summed up into 5 bullet points. Koil successfully defended against Tove's claims of joint ownership of the server. 2, the lawsuit was frivolous to begin with. Tove's conduct prior to filing the lawsuit was improper, which we will discuss later in the video. Koil deserves his lawyer fees to deter others or Tove from trying to sue again. And lastly, the Copyright Act allows for lawyer fees to be paid. This is all true. Koil's legal team cites that just to get to this point, Koil paid $222,000, and to prepare this motion, it cost them an additional $10,000. $10,000 is a bit excessive for this document, but you have to factor in LA rates, so we'll actually see how much Larry Zerner and his associates charge Koil per hour. At first, when I started covering this lawsuit, I was neutral. Koil had no employment contract with DW, and Tove was suing Koil for half of ownership, but Koil did say he had a license to DW's work, but did not prove it early on in the lawsuit. Emphasis on the lawsuit. Then some facts start coming out, one being that DW was only promised half the revenue from 4 of the 170 servers, as opposed to half of the revenue from all of the servers. So why would Tove sue for half of all the servers? Then Tove COO said that DW was loaned out to Koil despite never talking to Koil. And let's not get into DW working for Tove by streaming on Twitch and giving Tove all the money from Twitch. Even Tove's immigration lawyer had no idea that DW was being loaned out. It just showed that Tove and DW was trying to pull in the depth. Then once Koil proved that DW agreed to the TOS, granted him a license to all of DW's work, it was GG, but DW did not deny agreeing to the TOS. This motion is over 150 pages total. I am going to save some time. The TLDR, Koil is the prevailing party since he won on summary judgment. Prevailing parties are entitled to lawyer fees. It goes without saying that the court has the authority to grant Koil legal fees, but his team has to prove it, and this is where the lawsuit gets good.
But wait! There's more!
Outside of the debunking all of Tove's claims, the lawsuit was frivolous from the beginning. Tove could not produce any evidence of their claim, and they did not oppose one piece of evidence Koil's team presented. It took almost 2 years of litigation for DW to admit that him or Tove owned the content, but he did not deny signing the TOS granting Koil a license. Tove knew they never agreed to loan out DW to Koil, but went forward with the lawsuit anyway. Larry even calls out Tove, acted like they did not want relief under the Copyright Act, which would have opened them up to lawyer fees. So Tove thought they were slick, right? Referencing the Declaratory Judgment Act instead, but their claims were pursuant to the Copyright Act. They want their cake and eat it too. Think of it as Tove wanting to get paid from declaratory judgment, but wants to win the money using the rules of the Copyright Act. When it comes to, improper motivation, we could blame this all on DW because that's what this lawsuit all started with. You see, Koil's lawyer wasted no time in saying that Tove Tove/DW threatened to file this lawsuit in hopes of coercing a settlement from Koil. The lawsuit was filed with bad faith, as Tove was hoping that the legal fees being racked up by Koil would motivate him to settle.
See, as you can see, the more you fuck around, the more you're going to find out.
DW and Tove are finding out the hard way that Koil is willing to put up $250,000 to make sure that DW and Tove never recoup a penny from him, and this is how it should be. This lawsuit really is about DW accusing Koil of defaming him when Koil was sent a cease and desist letter on January 9th, 2023 for defamation as opposed to copyright infringement. DW accused Koil of defaming him when he referenced a former NoPixel employee caused a data breach at NoPixel, to which Tracy said it was not him, as he was working for another company, which we all know to now is Tove.
Was he fired? Yeah, I mean, pretty much. I mean, yeah. Then we started pulling access, and 20 minutes later, he magically downloaded a database. It literally was a download dump to his computer, his personal computer, because all the IP and shit's logged. And the craziest part is there was like logins to AWS, you know, other servers, but you know, access was pulled at pretty much all the same time. So I don't necessarily think it was to like do something hacky, or I think he might have just pulled the IPs and Steam IDs and shit like that and emails to like make a whitelist or some shit like that. Scummy, I mean, it's unethical for sure. I mean, it's illegal. That's why we announced it. Otherwise, I wouldn't have said a thing about it. Because if it was just like I think once it's an IP and an email, that's where you know, it's somewhat personal information that needs to be announced. But like,
he gave Koil 5 days to remove the statement and issue a new statement saying that it was not DW and to provide written assurance that he did it. You know, like what a moron. Hindsight is 2020, and I'm sure he regrets all of this. You know, what's funny about this whole lawsuit is Koil responded to DW saying he was not defamed, and Koil had the right to remove anyone he wants from the server with or without cause because DW signed the TOS. He reminded DW that the TOS granted Koil a license, you know, for all the DW's work. Also, Koil included a message from DW to which it reads, "My visa timeline got messed up. There's a 9-month gap where I would need to leave the US. We're applying for a new visa to bridge the gap, but it's as a gifted individual. Part of the requirements is publicity. Are you cool with me leveraging my work on NoPixel and talking about it in interviews?" You know, which why would Koil not? February 6th rolled around where Tove responded to Koil's email and was now making a claim of copyright infringement as well as defamation. They ended the email saying they would sue Koil if he did not remove the alleged defamatory statements. This is going to be critical as it's going to come up later. This series of events would prove that the threat of a lawsuit for copyright infringement was nothing but a threat to get Koil to remove the alleged defamatory statements. When Koil did not oblige, Tove sued for copyright infringement as opposed to defamation, making true on their word. I love how Larry worded that, you know, Tove manufactured a claim that they loaned out DW to Koil because, as I pointed out, the employment contract between Tove and DW is not notarized and easily could be manipulated to say whatever they want with any kind of date they want. So in order for Koil to call their bluff, he had to put up $220,000, roughly 364 hours went into defending this lawsuit, with Larry Zerner putting in 157 hours at $525 per hour. Keith Cooper, his rate was $525 an hour, was the partner of Morrison Cooper, which happens to be the law firm that represents some of your favorite streamers like XQC, Nick Merckx, and many more. No lie, the average person could not afford to fight this frivolous case for, you know, going on 2 years, but Koil is not the average person. With a platform that was generating $50,000 to $80,000 per month, he could afford to fight such a lawsuit. But if he couldn't afford to fight such a lawsuit, I don't think they would have sued. It's because he makes so much money per month, they're like, yeah, we can sue this fool. In addition to the $230K sought for Koil's attorney fees, he also wants an additional $44,000 in allowable costs to cover, you know, the depositions, the cost of transcripts, FedEx charges to serve subpoenas, and even the cost associated with Pacer, which, trust me guys, it can add up really quick. Okay, this brings the total amount requested to $276,000. This explains why the proposed order has a line for the judge to write in attorney fees and a line to, you know, add further costs to be awarded. It wouldn't be long before DW would respond. Now, I don't know what's worse at this point, the lawsuit against Koil or Tove's lawyer reasoning as to to why Koil should not be able to recover any legal fees after Tove did not dispute Koil's motion for summary judgment. Tove's lawyer lists 3 reasons as to why no legal fees should be recovered. 1. Tove did not dispute the motion for summary judgment. 2. The fact that Tove did not dispute the motion for summary judgment did not mean that their case was frivolous. And 3. Koil's claim that Tove sued in bad faith was based on the threat of suing Koil for defamation and it is inadmissible, and therefore the judge should disregard the whole statement altogether. These reasons are completely moronic and are literally a waste of taxpayer time. Name a case in American history where someone sued someone in federal court only to lose and not pay the person who they sued nothing. Almost all lawsuits filed, you run the risk of paying the other's attorney fees. This does discourage people from filing frivolous lawsuits, but here we are. Tove literally tried to mislead the judge, saying there was no controversy over ownership of the copyright. This is true, as Koil never said he owned the copyright. He said he had a license to use DW's copyrighted work, in which Tove said he did not, and tried to sell the NoPixel server as being a joint work. Next, Tove's lawyer tries to say they did not lose, but decided to conclude the lawsuit knowing that the court was not going to rule in Tove's favor, and tried to play this off as more of a negotiation instead of a judge deciding the outcome. The judge did decide the outcome when Tove admitted they never spoke to Koil about DW being loaned out to them, combined with the fact that DW agreed to NoPixel's TOS, proving that the lawsuit was indeed frivolous from the beginning. The judge gave Tove leeway to pursue the case by not dismissing it early on, only to learn the facts and realize there was never a case to begin with. Tove makes a claim that the facts Koil's legal team presented was not undisputed because they never were ruled upon. This is not the judge's fault that Tove did not file anything to dispute them. Tove got desperate, asking the judge not to consider DW's threat of legal action for defamation as a precursor to this lawsuit. Even so, you cannot unring the bell. Sure, let's just say that the judge does not consider it. The fact still remains that there was no evidence of a loan out program ran by Tove, and DW's visa looks sketchy as fuck. Lastly, Tove asks that if the court finds that Koil is due lawyer fees from Tove, that it only be half the fees Koil seeks. So Koil could, only get 150 because Tove's first claim, just their first claim, has a potential to award legal fees. Like, that's why they amended their original complaint to leave a backdoor open to wiggle out any legal fees. Toves bring attention to the amount of hours spent on the lawsuit and reminds the judge that he has the power to make an across-the-board percentage cut to reduce the amount of lawyer fees. In addition, they asked the judge to rule on if the DW defamation letter can be used, and the judge making a ruling. So, even if Tove wins this, there is no way a judge is not going to award Koil some type of legal fees, if not all. Now, Koil would respond to this, and it did not take long for Larry Zerner to respond to this reply. Like a shark who smells blood in the water, he latches on to what I pointed out earlier, how Tove said there was no controversy over the ownership of DW's copyrighted work / contributions to the NoPixel server. This directly contradicts the original filing, as Tove did file its complaint alleging copyright controversy, citing the Copyright Act. This did force Koil to spend over $200,000 fighting a lawsuit in which Tove knew it lacked merit. Therefore, Koil should get lawyer fees. Larry accuses Tove of denying their own claim, which they did, and ignoring law. You see, in short, Larry makes a case that Tove's lawyer is wrong about not owing lawyer fees because the scope of copyright was not addressed. Furthermore, it was not required to adjudicate the dispute for lawyer fees to be awarded because all that matters is a copyright allegation was made, which Tove did just that when alleging Koil did not have a license to use DW's copyrighted work after he was fired. Also, Tove did take a stance that they had joint ownership and interest to DW's copyrighted contributions to the NoPixel server. Tove's legal team is constantly moving the goalposts when it comes to this Copyright Act. When it benefits them, they like, yeah, Copyright Act. And when it doesn't, they're like, oh, no controversy existed. Now lawyer fees are being requested. Tove is arguing, no, there's no controversy over the Copyright Act. It never existed. It was only not dismissed because Tove said a controversy existed. Larry brings up Tove's inconsistency is exactly why Koil should be awarded legal fees. In addition, Tove had an opportunity to dismiss the complaint several times before Koil was forced to hire a legal team or take depositions. You know, what's really messed up is in the email exchanges, Tove knew that DW signed the TOS, granting a license to all of his contributions to the server. But, you know, sometimes people will take a chance, maybe hoping that the judge would, you know, void the TOS. There is still, like, you know, the loan out process issue, even if the TOS got voided. You know, all signs point to this being a lawsuit or, you know, as Koil said, a NoPixel lawsuit that never should have left the game, which, you know, I agree.
Congrats, dude. Like, just felt like another NoPixel court case. I wasn't joking when I said it. You thought I wasn't serious.
You know, as far as the letters, Larry says, you know, they are admissible because they are not used to prove or disprove the validity or amount disputed in the claim or show Tove contradicted themselves. It's just to show Tove's true intent or purpose. The letter shows Tove's bad faith and proper intent in the illegitimate threats made against Koil if he did not remove the alleged defamatory statements. Even if the letters are removed, it does not change that this was a lawsuit from the onset. Also, the reason Koil was going to win his motion for summary judgment is because the judge did not dismiss the case and all the facts came out and it was clear that Tove had no valid claim to the NoPixel server. You know, in terms of lawyer fees, Larry said the rates charged are far below what, you know, you would expect a lawyer with 30 plus years of experience, you know. And I'm inclined to agree because, you know, since they live in LA, their rates would probably be about $1,000 per hour, you know, at least $750. But, you know, in Larry's conclusion, he said, Tove saying it was resolved through negotiation is nothing more than an attempt to avoid for paying Koil's legal fees. In conclusion, they have a hearing set for December 9th, which happens to be my birthday. But how do you think the judge will rule? You know, there is without a shadow of a doubt, Koil will get some, if not all of his lawyer fees awarded to him. This judge should strongly consider the threats Tove made in sending letters to Koil when making their decision because they are very telling. You know, who says remove defamatory statements or you will get sued for violation of the Copyright Act. But, you know, who do you blame for this lawsuit dragging out for 2 years or as long as it did? You know, do you blame DW for probably having a play in convincing Tove to sue, or is it all on Tove for listening to DW and thinking they had a case? Or third option, do you blame Tove's lawyer for not telling them, hey, based on all the evidence you have zero case and you don't want to risk going forward with this lawsuit because if Koil doesn't settle, then it's game over for you and you're going to be entitled to pay legal fees. But, you know, either way, someone is going to have to pay in the end.